Assalamu alaikum, good evening. Apologies for the delay. We've had some technical problems today, but nevertheless, we're here. We'll get started. The first subject we're going to talk about will be immigration and the Home Office's changes that are proposed, as proposed by Ms. Priti Patel. Due to the technical problems, I cannot play the spiel to you. So, as ever, all of the discussion will be of a general nature. Please do not rely on this on your case or anything else, because you must take specific advice when you are dealing with your case. In terms of the process for asylum change, Ms. Patel has been very vocal, as have previous Home Secretaries and other politicians and some think tanks, that the asylum system is broken, it's in need of repair, it's not fit for purpose. We had heard that famous expression from John Reid, who was a Labour Home Secretary as long ago as that. So what we're going to look at today will be, in the beginning, just the general discussion about what's being proposed, and my colleague Rahil Latif will help us with that. And after that, we will then go into some of the more detailed things about the appeals process and what have you. So, Rahil, if I can start with you, do you want to just summarize for us? I'll remove myself for a moment. Just give us a brief introduction, a bit of background to this, please.
Okay, so I think the proposed changes which were laid out last week by Priti Patel draw on the sort of Brexit arguments and taking back control of the borders, and that is basically the main theme and the line in these proposals. And what we see is that on the back of as well the pictures we see in the Daily Mail and so forth, all the asylum seekers coming across on dinghies from France or other means of entering the UK, and the general sort of anti-immigration rhetoric we've heard over the last 4 or 5 years in particular, we've seen sort of what we call it, like a toughening up of the asylum process, or proposals to toughen up the asylum process. So I haven't sort of memorized the proposals, but there are some key points within the proposals which could, if they go through, have some significant impact on individuals seeking asylum in the UK. So what we see, first of all, as a backdrop to the proposals as well, is this claim that the UK has had its fair share of asylum seekers. And just when I was looking at that, there was a few figures I wanted just to raise about where the UK stands in terms of asylum seekers. And some interesting stats, first of all, I'd like to give some facts and figures. In the period to September 2020, the UK had only 31,000, just over 31,000 asylum applicants. And for a similar period, but up to March 2020, Germany had 155,000 asylum applicants, France 129,000, Spain 128,000, and Greece 81,000. So that sort of gives a context of where we really are with these proposals, and in fact it's more rhetoric as opposed to trying to sort out the situation. But moving on, we see that the proposals are going to sort of create a good and bad asylum seeker, where you've got the good asylum seeker, who's the one somehow is going to...
Sorry to interrupt you, but for the Home Office say good or bad asylum seeker, it's a bit of a ironic joke, but sorry, I'll let you carry on.
Well, what I mean by that is that those refugees or those individuals seek asylum from abroad and are then resettled in the UK, they'll be given indefinite leave to remain immediately and access to working rights, benefits, those sort of things, as if they are residents of the UK. Whereas those individuals, and most of whom make their way to the UK by whatever means they choose fit or whatever is available to them, those who enter illegally, they will be the bad asylum seeker, and they will not be entitled to what they have at the moment, which is refugee status for up to 5 years, thereafter entitled to indefinitely to remain. They will be considered for limited leave, which is 30 months leave to remain, which would not lead to any form of settlement. It will be extended if they have to remain in the UK. There will be a review as to whether or not... Sorry?
Sorry to interrupt you. So at the moment, somebody can't apply for asylum, roll up at an embassy, let's say somewhere in Asia or Africa, and say, I want to apply for asylum. Can you process my asylum application? There's no process for legally applying for asylum, and therefore you can only apply for asylum if you enter the country illegally. That's the legal position at the moment, right? As a matter of English or UK law.
That's right, yeah. So no individual can apply for asylum abroad, anywhere in the UK embassy or anything like that at all.
So it's a bit of a cheek to then mock people who have to enter illegally. It's a bit of a what's the word? Spin, to put it mildly. Well, they're all coming here illegally. Well, the reason they're coming illegally to claim asylum is because we don't accept a legal route. So hence the answer now that we're going to set up some sort of processing center elsewhere. What's the proposal, or what are the proposals in this regard?
Yeah, so that's where it's leading to. So within the proposal itself, the changes that they would lay before Parliament, and if they go through, would be to possibly, they say possibly in the future, have offshore processing centres. But at the moment, they're looking to get individuals to claim asylum under the UNHCR routes, possibly those individuals who...
Stop there. The UNHCR, I mean the United Nations High Commissioner for Refugees. So this is an organisation or a body that processes refugees in various camps around the world, for example.
That's right. So, and so those individuals who, for example, Syrian or Iraqi nationals may have made their way to Jordan and have been assisted by the UNHCR there. They've been recognised as refugees, and therefore they enter a resettlement programme. And in that process, in the last 5 years, this is where one of the facts in the proposals, in the last 5 years, up to 20,000 individuals have been resettled in the UK under this similar those sort of resettlement schemes. But those individuals have been given 5 years leave to remain as refugees, not indefinite, which is one of the proposals at the moment. Right. And yeah, so going back to the bad asylum seeker, if they enter illegally, they got limited leave to remain, and they get limited family reunion rights, as well as entitlement to benefit, limited entitlement to benefits. And
let's take each of these in turn then. At the moment, you're getting asylum visa, for want of a better word, for 5 years. Is that right?
That's right, yeah.
And then after 5 years, the Home Office have to assess your claim again. And if they think you're still in danger, you will get settlement. That's the current position.
That's right.
So what they're now proposing is that if you come through this route, we will grant you, if you're successful, a 2.5-year visa. Then you apply for an extension. I'm assuming they'll review it at that stage and possibly more regularly. And then if at the end of the 5 years, you're still at risk, presumably that may give you a chance to apply for settlement, although we don't know the exact detail.
Yeah, that actually hasn't been set out in the proposal. It seems to be open-ended in terms of they're trying to seek to remove that individual if the circumstances were to change. Is an assumption that someone's coming illegally didn't really have the legitimate reasons to come in the first place, and that's again one of the underlying themes there. The whole proposals are looking at two aspects. One is the individual. Why would the individual come illegally to the UK? Why there's a disparity between those who have the means to travel and those who don't. Those who genuinely need assistance are those who can't afford to travel. Therefore, they're the ones that end up in the refugee camps, and they're the ones that are most vulnerable. That's a
wholly irrational position, because you can be that's suggesting that only poor people can be refugees. Well, whereas many of the people who are political activists or outspoken critics may well be poor, but very often they are people who are reasonably wealthy, or at least reasonably well-to-do. So it's a bit of a bizarre principle. But in terms of the whole processing, because in terms of statistics, I was reading that at first glance, those that apply to the Home Office, approximately 38% or something are successful. So that means over 1/3 are accepted by the Home Office, even due to their skepticism that they're actually refugees. And I read somewhere that where the ones that go to the court, the first-tier tribunal, immigration asylum chamber, approximately about 40-odd% of those succeed as well.
43% succeed at the tribunal stage. That's right.
So pretty much more than 50% are accepted either by the court system or by the Home Office at first time of asking, as being people who have genuinely fled for their fear of life, safety, and so on. I wonder if the Home Office, well, I'm not encouraging them to do that, but if they compare the statistics to the criminal convictions in the magistrates' courts and the Crown Courts, whether they're thinking of doing these sort of bizarre proposals and targeting people, because this seems to me to effectively be a playing politics with the lives of many, many genuine people who are in fear of persecution.
Yeah, I mean, as I said, I agree with you on that. And if the one thing that struck me when I'm going through the proposal was that the terms or the words used is trying to couch it in terms of seeking to protect these vulnerable individuals who are being used by criminal gangs to make money, rather missing the point as to why individuals may be leaving their country of origin in the first place. No right person really would want to travel thousands of miles by, plane, road, foot, dodgy dinghy, with babies in their arms to get to a place of refuge if they didn't have to. So
let me put the Home Office point to you then. Let me often I say this, but let me put Priti Patel's point to you. Of the sort of 50 or 40 odd percent that fail, clearly they may have other reasons for fleeing. Could be poverty, could be some other reason, but they're not refugees. So the argument that would go against that would be to say, well, actually, there is clearly more than 50% on the face of it are being successful, but there is a substantial minority who are not genuine refugees. So one can see that point.
Yeah, that's true. There is an aspect there. However, another section of the proposal looks at the asylum process, and it's quite strange that they seem to say that the process is leading to backlogs, and the process is not dealing with these individuals quickly enough in the first place. And that's sort of justification to make the process even more stricter and difficult, rather than actually applying the rules which are there at the moment.
Well, that would suggest resource issues, because this is something I've been hearing, and I first came into this profession under the John Major government, or the back end of the Major government. It's been so long. So 20 odd years I've been doing this, and there's always been a problem of resource, and this is potentially endemic across the public sector generally. Under-resourced departments trying to deal with an ever-increasing workload inevitably leads to problems. And if the Home Office are now going to be looking at this asylum process at least twice instead of three times, sorry, initial claim and a renewal stroke settlement, it's not a recipe for good administration unless there's going to be resource, money and funding. And is there much money and funding, do you think, that's going to be promised in this?
There's very little said of actual funding itself. It's just a matter of trying to streamline the process, as I say. So there's very little figures about increasing the budget or increasing the workforce in terms of dealing with these applications.
In terms of the process for claiming asylum, we haven't been given detail, but presumably they'll be setting up mini home offices or mini home office sort of branches elsewhere, or perhaps relying entirely on the UNHCR to do the sort of asylum process.
Well, I think one of the things which is evident as well is they believe that there's an incentive to come to the UK, and they want to disincentivize the whole process, i.e. make it seem not attractive to make the journey to the UK by individuals, hence the change in the leave to remain if you're successful in an initial claim for asylum. But then the whole process itself, so should there be no offshore processing and individuals do make it to the UK, one of the things they're looking at is a semi-detention centre where you've got camps, which they've tried to have, I think, in Dover as well at the moment, camps where they will have a quicker processing of individuals, not a fast-track process, but processing of individuals who are not necessarily detained, but they will have access to legal advice on site. They'll have the quicker access to interviews and decision-making process, but within a confined and localized area as opposed to being dispersed around the country as well.
So effectively, asylum seekers are going to be given a carrot, which is if you claim asylum in Morocco or Jordan, they've sort of mooted these destinations, and we accept you, you're going to get indefinite leave to remain. So if you're very strong in terms of the prospects of your case are strong, you may well sort of opt for that one. But if you're not so sure, or you think, well, you know what, I can't risk being lumbered out there, and you make it to the UK, you'll get a second-rate refugee status or the grant of status. But ultimately, you still have safety, and all of this perhaps is subject to legal challenge anyway. And when you compare your sort of experience of 20 odd years in this field, is this an echo of I've heard this all before sort of thing, or do you think there is something genuine? Because they used to grant indefinite leave to remain under the Blair government for a short.
That changed back in 2005 to the 5-year leave to remain at the moment. Yeah. At the end of the day, they're not actually one, addressing the reason people are leaving their country of origin to claim asylum. So that's a starting point, which they probably don't accept and won't address anyway. And then you've got the fact that there are many reasons or many ways that individuals may make their way to the UK. People might already be in the UK, and circumstances change and they have to claim asylum. How will they deal with these individuals? Will they assume they are liars and that they came on false pretenses to claim asylum and deal with them in a harsh manner? We'll have to wait and see. I mean, what is ironic is that, as I've read, hopefully I'm not wrong, is that Priti Patel's parents were seeking asylum from Uganda from under Idi Amin. So,
asylum seekers, I think, because in those days you had Commonwealth citizens who had the right of abode. There was a man called Mr. Burke, who was James Callaghan's aptly named, I think, parliamentary secretary. He recorded a conversation where James Callaghan, the then Prime Minister, said, well, they're not real British people, are they? Sort of brown people. You remember the famous East African Asians case. They were British citizens who, through emergency legislation, were denied entry into the United Kingdom. Ms. Patel's parents were either from Uganda or Kenya. I don't know which part of East Africa. I think it was Uganda. Who came prior to the big crisis. But yeah, there is an irony in this. Mr. Sajid Javed, the bus driver's son, and Ms. Patel, I think they're a small retail company, they are the people that are used to beat migrants with the most. But yeah, I see what you mean. In terms of your experience and sort of drawing together the different strands, I mean, how hopeful are you that this will actually be a fairer and a faster processing of refugees? People are clearly vulnerable. I mean, if you talk about places like Syria and Libya, I mean, these are countries that through Western intervention or lack of intervention, i.e. support potentially, many people say, of tyrannies in the Middle East, that people have been reduced to having to flee these otherwise reasonably successful countries. So how hopeful are you that this will be there will be a positive outcome for the majority at the end of this?
Well, I think in anything, whenever someone's putting down proposals, they aim for the maximum to get some aspect of what they want. And if any part of this does go through, then it will certainly make things much more difficult for genuine asylum seekers. And that's the key thing there. We've already seen a restriction in the rights of appeal previously, and they're looking at that again. I can't see how much more they can strip away, but that's something which I think Saad may discuss in a moment. But yeah.
Oh, Saad's on standby. So if you give me your sort of final thoughts in a couple of sentences, then we'll bring Saad on to talk about appeals and the judicial reviews and all of those sort of things.
Yeah, I mean, at the moment it's only proposed. There's a lot of things in the air. Some of the proposed changes, if they do go through, will raise issues for asylum seekers, so the credibility issues, which have their own reasons that have to be considered. But overall, I think we'll have to wait and see what actually does take place, and then we can take it from there. There's nothing much more we can say at this moment in time.
Okay, well, thank you very much for your assistance. I'll bring Saad on board. So it's Assalamu alaikum, goodbye to you.
Welcome, goodbye.
And we're now waiting for Saad to join us. So if you're just tuning in, or when you watch this afterwards, we're looking at the issue of immigration and asylum. And the whole idea here is that the government have announced this big scheme that they're going to actually fix this system. We've been hearing this for the last 20 odd years, certainly I've been in practice. Let's see, you've heard Raheel explain about the process and about how it works at the front end. And we're now going to talk about the court process, the appeals and the judicial reviews, which are much maligned. So I'll ask Saad to join us. Saad, assalamu alaikum, good evening. Thank you for joining us.
Wa alaikum assalam, and thank you for having me.
Right, you've got a double on today. You're going to talk a little bit about employment, a little bit about immigration appeals. So there is all this mud being thrown at the immigration courts, Ms. Patel, and as have her predecessors, that judges were convinced of believing desperate people and allowing their appeals. I mean, you've been doing this, 15, 20 years, going to the courts. Well, are judges soft and foolish or impressionable that they'll believe any old nonsense that they're told by a dodgy asylum seeker?
Well, in two words, absolutely not. No. Judges are very experienced people in the legal field. You know, they've had years of experience either as solicitors or barristers themselves. They then go through rigorous training before they become judges. They're well versed. well experienced in sorting out the liars from those who are telling the truth. And anybody who's been in the tribunal hearing in the Immigration and Asylum Chamber will know that anybody who puts forward an account which is unbelievable and is not the truth is going to get found out, and it's very difficult to pull the wool over the judge's eyes.
So it's not a walkover, and the Home Office are talking about introducing new powers in law about fast-tracking appeals, because there was the old, now declared unlawful, the detained fast-track scheme. That's one fast-track process. They want to try and reincarnate that. Is that right?
Yeah, that's correct. They are talking about having a process. They don't refer to it as fast-track, but from what I've read, in essence, that's what it's going to be. They do make a point that they have to ensure that it is fair, and they want to have adequate controls where cases which are more complicated and can't be, let's say, dealt with quickly are taken out of this scheme. But for those, again, who worked in the previous fast-track schemes in the early 2000s, mid-2000s, will be fully aware this sounds very much like the scheme that went on beforehand.
I mean, clearly the government suffered defeats ultimately, although it was not ruled unlawful very early on, but eventually the courts had that view. But many people will say, well, look, ultimately the courts in the latest, sort of the Shamima Begum case about nationality, are being more deferential and showing more deference to effectively, well, there's political accountability, and if people don't like this sort of process, they can vote out the government. So is there a worry that perhaps, of course we hope not, but perhaps the judiciary may not be as demanding on the standards that previous senior courts judges have been? Do you think that that may be possible?
My own personal opinion is no. I mean, look, we've had a system in place for decades now where people have come, they've made applications for asylum. Many have been granted and many have been refused. And we've had an appeal system which has been going on for decades as well, where people have been going to the tribunals, putting their cases before judges, having them heard, having them decided. Many, again, have been granted, as you mentioned before. Many have also been refused, and they've had onward rights of appeals to the higher courts. And again, a lot of them are refused, but many of them are also successful and granted. And the whole point is that, look, at the end of the day, the system is run by human beings, and human beings are always fallible. And they will always make mistakes. There's never going to be a perfect system. And that's why the whole appeal process exists, because the very nature of the appeal system is a recognition of the fact that human beings, i.e. the caseworkers that work for the Home Office and make these decisions, are not fallible. They make wrong decisions. And those decisions have to be corrected at an appeal. And the whole reason for the onward appeal process is because it's also recognized that judges themselves are human beings and they can also make the wrong decisions. And years in practice have quite clearly shown that if the appeals system didn't exist in its entire format, so with all the rights attached to it, then there would have been several miscarriages of justice, and undoubtedly the UK would have sought to return or even returned many people who would have been persecuted if they were returned to their countries.
We're looking at over 40% of appeals are actually successful. So given that the Home Office refused 2/3 of people, and just shy of half of those, so a sixth, which is what, about 16% of the total applicants are being refused. I mean, that's, it's so to the 1/3, 2/6, sorry, 1/3, give or take, are successful. That's a big concern. So hopefully the appeals process will stay intact. Now, there's a lot of talk about the judicial review process being abused, and the Home Office wanting to cut out what are called CART and EBA JRs, which are judicial reviews of the appeal tribunal, the upper tribunal decisions, where you've got no right of appealing to that tribunal if it's been refused. Now, there seems to be more substance to this argument because far fewer are successful. But again, many might say, well, the fact that a few succeed given that it's an entirely paper process. It's not like a laborious process. Clearly, judges do have to take some time to respond or review the case. Do you think that's a fair comment by the Home Office and a justification, given that the numbers that succeed are not very high?
Personally, no, I don't. I mean, I see where the Home Office are coming from. They've looked at the statistics and they've thought, well, there's been so few people who are succeeding that the system is really not worth, the paper is written on. But looking at it from the other point of view, that also means no matter how few people have been successful, people have still been successful. And again, it goes back to the whole point that no matter how many times your claims or your appeals may be assessed in the judicial system, there is always room for error. I mean, I know one senior Court of Appeal judge, I think, once said that when we look at the criminal system, not everybody in prison is guilty. And if we look at everybody who is out there on the streets, not everybody is innocent. And that's just the fact of life. That is just the reality. So I understand, the government are thinking, let's take away this way of challenging our decisions, because ultimately, the less challenges they face, the more they can get away with. But from a purely constitutional point of view, the whole concept of judicial review is a check and a way of balancing acts done by the government which are contrary to either human rights laws or principles of public law. And if those checks were taken away, then it would leave the government room to act with impunity, which nobody wants to see.
Okay, and one of the justifications we have, and again, it's not unique to the immigration system, but it seems to have been picked up and amplified. Well, there are many dodgy liberal lefty solicitors, and we saw some very negative publicity, and therefore they sort of game. I think I saw the expression "gaming the system," playing the system, or messing around with the system. Now, let's accept there are some that do that. Effectively, it's taking the exception and making it into a norm, and therefore using that as a big stick to deny the vast majority of people the right to the court system. Do you think that's a fair observation?
Yes, no, I absolutely not. I mean, we hear often in other areas, things like football, things where there's abuse going on in Twitter, that is always a small minority. And that small minority shouldn't spoil everything for the majority. Well, let's apply that principle here as well when it comes to lawyers. I mean, I don't agree with these comments by various people in the government about lefty lawyers, but let's assume for one moment that they're correct. And out of hundreds or thousands of lawyers across the country, if they were to even pick maybe 5 or 10 or 15 or 20, let's say, lefty lawyers, that's less than 1% of the amount of lawyers in the UK that are working in this field. And again, let's apply the principle where the small minority, if you think they are, a little bit, let's say overzealous, if they are, they shouldn't be spoiling it for the whole majority. And it's wrong, in my opinion, to pick on those few examples to show that the whole system is failing, when actually that is not the case. If the system is failing, it's not for those reasons.
And in terms of the curbs on judicial review, for example, and there's an idea about making the appeals process more difficult. I've heard of this expression, and a one-stop shop or a one-stop regime, but that already exists, doesn't it?
Yes. So let me read out a couple of things. So in the policy announcement, I've read 2 things. First of all, the government wants to introduce some kind of good faith requirement. And what they say is that anyone bringing a claim or challenge in the courts and their representatives will be required to act in good faith at all times, which means bringing any claims as soon as possible, telling the truth, and leaving the UK if a person has no right to remain. Now, that part of the announcement makes it appear that there is no good faith requirement already, when in fact, actually there is. There is already a good faith requirement, not only for people to tell the truth and for representatives to act in accordance with the code of conduct and professionally, but also for them to make claims as soon as possible. So Yes, it already exists. And coming to what you mentioned, the one-stop process, again, another part of the announcement was that they call it a new one-stop process, will require people to raise all protection-related issues up front and have these considered together and ahead of an appeal hearing where applicable. Again, it makes it sound like the system doesn't exist, when in actual fact it already exists. In fact, it's existed since the early 2000s. And as we both know, there has been a one-stop process. It was brought into law, I think, from the 2002 Act, the Nationality, Immigration and Asylum Act 2002. It was brought into effect there to stop the very notion of people making repeated claims time and time again. And as you know, when anybody ever makes an application for asylum in the UK, at the time of claiming asylum or shortly thereafter, they're issued with what we call a one-stop notice. The one-stop notice makes it very clear that if that person has any other reasons why they want to remain in the UK, they have to divulge them at the beginning, up front. And if they don't, then either those parts of their claims will not be considered, or will not be believed, or will not be accepted. So the process already exists. So this announcement from the government that they're going to create a new one-stop process, I'm struggling to see what they're talking about when it already exists.
Maybe it's a bigger font and on every page or something. Anyway, sorry, I'm being a bit truculent here. I think, so when one looks at the wasted cost orders, for example, and fixed costs in judicial review, it seems that this is again a hit at potentially solicitors or lawyers, as well as the people bringing the claims. What do you think about that? I mean, at the moment, clearly there isn't a presumption for a wasted cost order, but that seems to effectively start the process as there should be one, unless you can show me why there shouldn't be, rather than a judge being given the power to say, well, if you think the conduct is so egregious, so unacceptable, that no reasonable lawyer should have prosecuted it, that you should, or no reasonable claimant properly advised should have brought it, that you should then consider making a wasted cost order. I mean, that really two different things. So the idea of a presumption seems to be very punitive.
Yes, I would agree entirely with that. And I think effectively what it sounds like here is in an attempt to reduce the number of claims being made by lefty lawyers, or any lawyers as you want to call them. What the government is now proposing is that the lawyers won't get paid. They'll get a fixed amount. They may set the amount at such a low level where financially it's not worth the time of a lawyer. So they're hoping then through the back door, the lawyer will advise the client it's not worth making your claim simply because the amount of time we have to spend on it is not financially viable. Now, the only result that that can achieve is that any meritorious claim, which may not be financially viable, then risks not being made at all. And when we're talking here about basic human rights, and when we're talking here about asylum, the right to life, the right not to be persecuted or harmed, these are very, very serious issues which should not be stopped from going to the courts for purely financial or commercial reasons. Okay, so I do fear that it will have a knock-on effect on valid claims, and the innocent, as always, will suffer as a result of this. Now, when we talk about wasted cost orders, again, it's nothing new. The first tier tribunal and the upper tribunal already have powers to order wasted costs against any party, so that can be the representatives of the applicant who is claiming asylum, or even the respondent of the Home Office for behaving unreasonably or in other ways which are not right. The judges can exercise those powers. They have the right to exercise those powers. And we are seeing, as time goes on, that there are instances where they do clamp down and they are exercising those powers, albeit rarely at the moment, but those powers can be exercised more and more frequently if they think they need to. But I think the fact that the judges are exercising those powers rarely at the moment actually shows that it's because there isn't a need to exercise those powers more widely, because on the whole, by and large, the representatives, not only of the asylum applicants, but also of the Home Office, are acting reasonably and properly.
Okay, and sort of just to conclude, we will go into the detail when it's published, because at the moment it's just an outline proposal. We don't have the nitty gritty. But in a sentence or two, do you think these sort of the more outrageous or the more outlandish proposals that are being sort of sounded out will survive a decent legal challenge in the higher courts as being fair or compliant with the Human Rights Convention and possibly even the European Convention of Human Rights?
Well, obviously that remains to be seen, and nobody can predict the future. But you know, the job of the government is to try and stretch the boundaries. Let's say, you know, if we took the parent-child relationship, you know, the children always try to stretch the boundaries set by the parents. And in a similar way, what the government is trying to do here is stretch the boundaries of what they can get away with. And as I said before, the whole point of having the court system and the point of judicial review is that the government is checked and there is a balance so that they're held to account when they go too far. So one would hope that if the government tries to exercise some outlandish powers, obviously the government, the courts, in their role as a supervisory body, in their role as in the checks and balance system, which is part of the UK's constitution, will hold the government to account and make sure it doesn't happen.
Thank you for that. Ray, I'll just bring you back in. What are your thoughts on this in terms of any concluding remarks before we bring Saad on for his employment law stint?
No, I think whatever Saad said is spot on. I think, as always, he's quite accurate with the concerns that we do have for valid, genuine claims and how innocent individuals maybe slip through the net once again in the proposed changes. But we'll have to wait and see what happens.
Perfect. Well, Rahil, thank you very much for us. You're free to enjoy the rest of your evening. Assalamu alaikum from us to you. And
goodbye.
Bye. Mr. Saeed, let's take two. So now we have Saad still with us. Saad, we want to talk about employment law, and today is a light sort of canter through the process. So let me put myself in the position of being a disgruntled or grieved, somebody who's been grieved by the whole process. My employer has either made it impossible for me to carry on in my job or just plain sacked me. I've tried my lot with ACAS. They haven't really come up with any of the goods. So can you walk me through the process and timescales? How long do I have to take a claim to the Employment Tribunal, first of all, after I get the letter from ACAS or while I'm with ACAS?
Okay, all right. So now that I put my employment hat on, let's talk about the process for making a claim. So it's very important for the viewers out there to know time limits in the employment tribunals, because sometimes they can be adhered to very, very strictly. And if you're even 1 day late, it can mean the absolute demise of your claim. And also for any employers watching out there, they need to know these time limits, because then they have the power to make sure that claims which are late are properly defended in the manner in which they ought to be defended. So to answer your question, we're right at the end of the process where you have gone through ACAS conciliation and you've received your certificate. Now, let's say you received your certificate today.
Yep.
So today is the 29th of March. The certificate would have on it the 29th of March as the date of issue. You have 1 month minus 1 day to make your claim in the employment tribunal. So that doesn't mean the 29th of April, it means the 28th of April. So everybody
1 month means a calendar month.
Yes, exactly. But where we always see people calculating wrong is they think if it's the 29th of March, I have until the 29th of April.
Yeah.
But it's not. So I always say the easiest way to work it out is 1 month minus 1 day. So everybody knows
clear enough.
1 month. Yeah, everybody knows 1 month from 29th of March to 29th of April. And then minus 1 day means the 28th. So that's the deadline. And it's also important for everybody to know that is not the deadline for you to send your claim or for you to submit your claim. That is the deadline for the Employment Tribunal to receive the claim. So in practice, if you're sending it by post, if you're filling in the form in hard copy, you need to make sure you send it off a few days before. You need to make sure you use a registered post service that makes sure it gets there before the deadline expires. or if you're submitting it online, you need to make sure that it is actually submitted and received by the tribunal office before the deadline expires.
Okay, so it's 28 days or 1 month minus 1 day, 1 calendar month. Now, obviously, the personal details are given. You've got to fill in the bits about you, bits about your employer, how to contact you, and so on. If you need a solicitor to advise you, you should instruct one or get a solicitor as soon as possible. And in the meantime, have presumably all of the documents that are relevant, any emails between you and the employer, any correspondence with ACAS, and anything else which will help the employer understand the history, correct?
Yes, absolutely correct. So, I mean, look, you know, in our job, there are many ways in which we can do it. But to be completely honest, for a legal representative to properly draft what we call the particulars of the claim, so the details of what the claim is and the allegations and the claims being made and the remedy being sought, for them to draft that absolutely accurately and properly, it's very important for the person to bring as much evidence and as much correspondence with them at the outset, so that the legal representative can go through it and make sure everything in the claim is spot on.
Okay, so there's 2 possibilities. One, that I could bring you an absolute howler of a claim, which you think, oh my God, I wouldn't touch this with a barge pole. But if I'm dead keen, even though there's no legal basis, you know, maybe I am aggrieved. Is there a risk that if I take that case and a judge is absolutely, you know, goes blue in the face, looking, why, you know, what the hell are you doing in my court? Am I likely to get costs against me?
Yes, that's a very, very good question. Right, so let me tackle it like this. In the first instance, if a legal representative was to come across somebody who wanted to make a claim, whatever the situation, no matter whether he had a legal claim or not, the first thing is that as a legal representative, we would obviously advise them that they don't have a claim, a legal basis for any claim. And we would say to them, look, you know, there is really no legal basis for this claim, and we would say to them that you should not therefore make one. However, if they were absolutely hell-bent on making a claim no matter what, then yes, you're right. There are a few things that can happen. First of all, after making the claim, what happens is that the tribunal sends a copy of that claim to the employer. And the employer has 28 days from when they receive it from the tribunal to put in a response. Now, as an employer, if they see that the claim has got no legal basis, then they can defend it and they can ask the tribunal to strike out the claim for that very reason, i.e. there is no legal claim here, there is no legal head of claim, there is no basis for any claim, and therefore the claim should not be allowed to proceed any further. Okay. The employer can also then give the person who's made the claim a warning that if you do not withdraw your claim, then they will seek costs against that person for wasting their time. Okay, so we talked even, you know, earlier on in immigration about checks and balances. Within this whole system, even within the employment tribunals, there's this whole system of checks and balances where the power can shift from one side to another, and the whole idea is to prevent abuse of the system. So yes, for somebody who makes an unmeritorious claim that has no legal basis, they do need to be aware that these are the possible outcomes, and sanctions can be put upon them. Okay,
so in terms of funding, how is it possible that my home insurance, motor insurance, or some sort of insurance policy may cover the expense of bringing an employment claim? Is it possible?
It's quite possible, yes. I have seen in the past mainly 2 types of claim which can be covered either by car insurance policies or home insurance policies. And those are either claims for unfair dismissal or claims for discrimination, either in the workplace or even sometimes outside the workplace. Now, I'm not saying it's standard across all policies. You know, all policies are different and everybody should check their policies, but it can be done. So if you think that you have that kind of cover, if your policy states you have some kind of cover, by all means, the policyholder is entitled to contact their insurance company, and the insurance company will most likely provide them with a solicitor that they have on their panel, and you'll get free advice and free assistance through the policy. There are also what we call after the event insurance policies, which one can take out as well. to cover claims for possibly unfair dismissal or discrimination, or maybe even some other claims. But those are specialist insurance policies which people take out purely to make a claim, and those vary depending on the claim and depending on the circumstances.
So you put the claim in, the employer's been sent the claim form, they defend the claim. In terms of the number of witnesses, clearly you as a lawyer would want to test those witnesses before you put them in as witnesses, because sometimes you might think somebody's helping your claim, but they could in fact be sinking it or supporting the fact that you don't have a claim. So again, I need to check with the people who I say witnessed X, Y, and Z, whether it's harassment, whether it's sort of bullying or whatever it might be, and make sure that those people actually do confirm that they did hear what I say they heard and they did see what I say they saw. Otherwise, it could be extra expense in terms of legal fees, and then possibly a serious danger in court if they're not a good witness, or if they effectively contradict or undermine what I'm saying as the claimant.
Yes, definitely. That's absolutely correct. I mean, there is absolutely no point in you bringing a witness who is going to give evidence to support the other side, the other case against you. So yes, definitely, all the witnesses must be checked out and screened. You know, one, to make sure that the evidence they give is in your favour, not against you, but also sometimes people may be willing to give evidence in your favour, but they may not actually make good witnesses in the court setting, because they may get too nervous, or they may think that they want to help you too much and try to overexert themselves and come out and maybe do some damage to your claim. So yes, it's very, very important. Any witnesses that you think you have in your claim are actually good witnesses. And when we say good witnesses, not in just your opinion, but actually good witnesses, but also that they're reliable. Because one of the things that I see most often is that at the outset of the claim, a lot of people are always willing to say, yes, I will help you, I will help you, I will help you. When the date for the hearing actually gets set, and you ask them again, can you come on this day to my hearing? Then they say, oh, I'm busy, or oh, I'm not sure. You know, they start umming and ahhing, which means actually they weren't reliable in the first place.
Okay.
So it's very, very important to make sure that the witnesses are reliable and good at the outset of your claim, not later on.
Understood. So we've got through the process. You've got to the stage now that you're approaching the court hearing date. All the documents have been exchanged. We forgot to ask, is there any appeal fee? And do you have to pay anything to the court to bring a case to the Employment Tribunal?
Right. So when you make your claim to the Employment Tribunal, there is no fee. There was a time when fees were being charged, but the Supreme Court ruled that those fees were unlawful. So for a period of approximately, let's say, 2 years, people were paying fees, but those fees were abolished a number of years ago, so there is absolutely no fee.
Okay, so in terms of the court case, we go to court and, you do a cracking job and we win. Now, what happens? Is that the end of the matter, or can the employer or the losing side appeal?
Right, so the losing side, or even you could say the winning side, because either side can take up these rights. There are two ways of challenging the decision of the Employment Tribunal. One is to ask the tribunal that made the decision itself to reconsider its decision. And for a reconsideration to be effective, you have to show it's in the interest of justice for the decision to be varied or revoked or changed in any other way. The other way to challenge it is by actually appealing to the Employment Appeal Tribunal. And that is a separate process. In order to succeed in that, you have to show that the Employment Tribunal made an error of law, which means they didn't apply the law properly when they considered your claim. And both have different time limits. So there is a 14-day time limit which applies if you want to ask for a reconsideration. And there is a 42-day time limit if you want to appeal to the Employment Appeal Tribunal. And
just while we're concluding, just a few final bits of advice to potential employees for today. We can look at it from an employer's perspective another day. When this process, because very often you will see people coming to you after they've been sacked or they've been forced to leave, but if there is any problem that arises in an employee-employer relationship, would it be wise to take advice or counsel from somebody such as yourself or anybody else at that stage, so as to understand the lie of the land and to do what's necessary to preserve their position? Or is it just, don't worry about it, wait until the end?
No, it's definitely worth seeking advice in the initial stages, or rather when anything happens, or maybe even about to happen, because there are cases where the correct course of action may be for the employee to resign, and if they're not aware of that and they don't resign, that could be detrimental to their onward claims. And similarly, there are some claims which arise in the course of employment, which have time limits, for which you may not need to be dismissed. So, for example, you may not have been paid your wages for a particular month or 2 months, whatever. Well, time runs for that. You don't need to be dismissed for that. Or you may have suffered discrimination in the workplace without being dismissed. Again, time runs while you are working in that job. So people need to seek advice up front so that they are aware of all of their rights and the time limits which may apply. If they wait until they're dismissed, they could be too late. There is always that risk.
Okay, so in conclusion, when you have a problem in any employee-employer relationship, take advice as soon as the problem starts, so as to ensure that you are doing everything right. And if things have gone wrong or are broken down so badly, then take prompt advice to make sure that you go to ACAS in time. And what time limit do you have for going to ACAS after any relationship breaks down?
A very good question. So the time limit for going to ACAS, I think the best way to explain it runs from the date that the act that you're complaining about. So if it is an act of dismissal, then it will be 3 months minus 1 day from the date of dismissal. Or, well, to be clear, the very latest you can go to ACAS is 3 months minus 1 day from the date of dismissal, because actually you can go to ACAS at any time after you're dismissed. Okay. If you were complaining of an act of discrimination, then again you can go to ACAS at any time, but the very latest is 3 months minus 1 day from the act that the discrimination occurred. And again, to give another example, if you're complaining that you haven't been paid your wages or the right amount of wages, then you can go to ACAS at any time, but the very latest you can go to ACAS is 3 months minus 1 day from the date that you were not paid the correct amount of wages. So there are different time limits for different types of claims. And in summary, you can go to ACAS at any time, but you should always go to ACAS, always make sure you contact them within 3 months minus 1 day.
Okay. Any final remarks before we close for today in terms of the basics of bringing a claim in the Employment Tribunal?
No, I think you've covered all of it. But to summarize, it's very important people understand their rights properly. Very important they stick to their time limits, and it's very important that they make claims which are actually well-founded and have some kind of legal basis. Otherwise, you're going to be in trouble. You're not going to have a good experience, and you're going to feel hard done by as well. So in order to avoid that, please always seek legal advice.
Okay, thank you very much. And if you're just joining us, just to confirm that all advice given is generic in nature. If you want to make a claim or need to make a claim, make sure you take expert advice from somebody who knows what they're doing. And please do not rely on the advice that's been given today for guidance purposes, because you may misunderstand and therefore suffer loss. And of course, Aman Solicitors Advocates will not accept any responsibility for that. Today we've had some technical problems and we apologize for those, but nevertheless we've managed to get through this, and we may well have our very last live stream next week, because the format will be changing and we'll be producing content and sending it out in a different manner going forward, possibly from 2 weeks from today. So until next week, which may well be the last live stream or possibly the last but one, it remains for me to say thank you very much, Saad, for joining us.
Thank you.
Assalamu alaikum from Saad, and Assalamu alaikum from Islam, Saad.
Wa alaikum assalam.
Right, I'll just end the broadcast. Bear with me.